Welcome to SQE1 preparation, criminal practice. On this post, we're going to focus on public funding and legal aid by Street Lawyer, helping you to pass first time. When it comes to the FLK2 criminal practice specification, what does the SQE1 expect you to know? Well, it says this. It says first hearings before the magistrate's court, and you can see in the middle in red applying for a representation order. So it's important to know about public funding at the police station stage, the magistrate stage, and also the Crown Court stage. Learning outcomes for this post is by the end of the video you will be able to hopefully explain the availability and scope of legal aid, apply the interests of justice test to practical scenarios, assess eligibility under the means test, and understand the appeals process for denied applications. Then there's a series of test your knowledge questions, and you'll see at the end of the post that the answers are there. So please, if you want to go straight to it, then you can go straight to them. But let's just go through it together. Question 1 is legal aid at the police station is means tested, true or false? Question 2 is universal credit recipients automatically qualify for legal aid, true or false? Question 3, a defendant can appeal refusal under the means test, true or false? Question 4, exceptional hardship applications require CRIM 16, true or false? Question 5, legal aid is always free in the Crown Court, is that true or false? Question 6 is the interest of justice test includes reputation damage, true or false? Question 7, all minors under the age of 18 automatically qualify for the means test part of legal aid, is that true or false? And question 8, legal aid in the magistrate's court requires contributions, is that true or false? Test your knowledge 2 is about Steve. Steve has been arrested on suspicion of common assault. He's employed as a head teacher, earning £100,000 per year. It is alleged that Steve punched a work colleague whilst at a work function in a restaurant. Steve denies the offence and has never been interviewed under caution by police before. Will Steve be entitled to publicly funded legal representation in connection with the defence of his case? And you get options A, B, C, D and E. A is Steve will not be eligible for publicly funded legal representation by the duty solicitor at the police station because he will fail the means test. Option B is Steve will be eligible for publicly funded legal representation by the duty solicitor at the police station, limited to telephone advice only. C is Steve will be eligible for publicly funded representation by the duty solicitor at the police station and at all hearings up to and including sentence. Option D is Steve will be eligible for publicly funded legal representation by the duty solicitor at the police station. He will also be able to get representation other in the magistrate's court provided that he passes the interest of justice test because there is no means test in the magistrate's court. Or is the answer E, Steve will be eligible for publicly funded legal representation by the duty solicitor at the police station. He will not be able to get a representation order in the magistrate's court because even if he passes the interest of justice test, he will fail the means test which applies in the magistrate's court. Test your knowledge 3. Steve, age 17, is charged with a minor common assault. He has no previous convictions and is pleading not guilty to the charge. He has been identified by the offender by a witness. The witness saw him a couple of seconds late at night when it was raining. Steve disputes this evidence. Steve's parents are acting as appropriate adults and have significant capital assets and both earn high incomes. Will Steve be granted legal aid to be represented at trial? 5 options. A, no, legal aid will not be granted as the offence is minor and not likely to attract a custodial sentence. B, no, legal aid will not be granted as Steve's parents are acting as appropriate adults and have significant assets and high incomes. C, yes, Steve is a youth and under 18, so Steve will automatically be granted legal aid regardless of the nature of the case. Or is it D, yes, Steve is under 18 and the hearing of the offence will involve a substantial question of law. Or E, yes, as it is in the Steve's best parents' interest that he is represented given the effect of their reputation. Then you have test your knowledge 4. This is from the sample SRA's website So this is quite an important one if you're to be guided by anything like what it's going to be like in the exam. A man has been arrested on suspicion of common assault. He is a professional football player earning £180,000 per year. It is alleged that the man punched a photographer who was trying to take a picture of him whilst he was having a drink with a woman in a bar. The man has never been in trouble with the police before and has requested that he is represented by the duty solicitor while he is interviewed under caution at the police station. Will the man be entitled to publicly funded legal representation in connection with the defence of his case? 5 options. A. The man will not be eligible for publicly funded legal representation by the duty solicitor at the police station because he will fail the means test. B. The man will be eligible for publicly funded legal representation by the duty solicitor at the police station and at all hearings up to and including the sentence. C. The man will not be eligible for publicly funded legal representation by the duty solicitor at the police station, limited to telephone advice only. D. The man will be eligible for publicly funded legal representation by the duty solicitor at the police station. He will also be able to get a representation order in the magistrate's court provided that he passes the interest of justice test because there is no means test in the magistrate's court. And E. The man will be eligible for publicly funded legal representation by the duty solicitor at the police station. He will not be able to get a representation order in the magistrate's court because even if he passes the interest of justice test, he will fail the means test, which applies in the magistrate's court. So now we go on to the content itself. Question: what is legal aid? Definition: publicly funding to ensure fair representation in criminal proceedings for those without sufficient means. Legal basis is Article 6.3 of the European Convention on Human Rights, ECHR. The scope of legal aid covers legal advice and representation in police stations and at court. Question: is legal aid available for work done at the police station? Yes, it is available, and a couple of key points here. It's free to all individuals being interviewed by the police under caution regardless of means. You could be extremely poor, you could be David Beckham. You will be entitled to free and independent legal advice for if you've been interviewed under caution. It covers both those who are arrested and voluntary attendees. It includes advice under the police station advice and assistance scheme. Question: is legal aid available for work done after charge? Yes, subject to 2 tests being satisfied. Interest of justice test must demonstrate public interest in representation, and means test must prove insufficient personal finances to cover representation, and a person completes a CRIM 14 form. So now we look at the criteria in a little bit more detail. So the first part of the criteria is the interest of justice test. What that is, it basically is that there's a likelihood of a loss of liberty or livelihood or serious damage to representation. It could involve cases involving substantial questions of law. Defendants may be unable to understand proceedings or present their case. Need for witness tracing, interviewing, or expert cross-examination. And it could also involve representation serves another person's interests. And what's important is to, when you get an MCQ, SBAQ question, is to work out which of these will satisfy the interests of justice test. So we go into a little bit more detail now. So what does factor 1 mean? So factor 1 is about likelihood of losing liberty or livelihood or serious damage to representation. Examples of who would qualify if it's likelihood to lose liberty: defendants with prior suspended sentences charged with theft faces likely custody. Example: defendants facing a refusal of bail. Likelihood of those who would lose livelihood: defendants face conviction, which means they are likely to lose a job or prevented from working with children, and that could include people who are self-employed, e.g. taxi drivers or lorry drivers. Likelihood of serious damage to representation, such as those defendants who've got standing: school governors, head teachers, facing damage to representation if they are convicted. You've got examples of who doesn't qualify: defendants charged with minor road traffic offences, unlikely to result in any imprisonment at all, specifically speeding offences. just think about carefully when you get an SBAQ question, would it satisfy this factor? What does factor 2 mean? This one's about substantial question of law. So examples where you could find it in SBAQ questions is where there's disputed issues about admissibility of hearsay evidence, forensic evidence, ID evidence, or about whether bad character proves conviction should be admissible or not. Examples: what wouldn't qualify, pretty much straightforward shoplifting case where there's no legal complexities. Factor 4 is about witness tracing, expert cross-examination. So examples that would qualify: potentially an alibi witness needs to be located, evidence requiring forensic experts, cross-examination requires of an ex-partner in a domestic violence case. Examples of what wouldn't qualify for this factor would be no witnesses or expert evidence involved. And then you got factor 5, another person's interest. Example would be cross-examination of a vulnerable victim requires sensitivity. Examples of where wouldn't qualify is the case does not involve any vulnerable witnesses or dependents. Can a defendant appeal a refusal based on the interest of justice test? Yes, they can. The process is to provide additional information to the legal aid agency using the CRIM 14 form and requesting a reconsideration of the application. Now we move on to the second part of the test to obtain publicly funded representation, legal aid. It's the means test. So what is the means test in the Magistrates and Crown Court and the Crown Court? Well, this is subject to meeting the income threshold. Savings are not taken into account at the Magistrates Court, but they are taken into account for a representation order at the Crown Court. There's no contributions in the Magistrates Court, but there are contributions depending on the full means test at the Crown Court. And then you got some figures there, and those figures could be subject to change. And you can see that for yourself. Who automatically satisfies the means test? Categories who automatically are eligible for legal aid are those on income support, income-based job seekers allowance, state pension credit, income-based ESA, employment support allowance, universal credit, and anyone who's under the age of 18. They automatically satisfy the means test. Example is single parent on income support with no savings qualifies automatically. Again, just to re-emphasize this point, capital or savings not taken into account at the Magistrates Court. Question: what happens to those who do not automatically satisfy the means test? Well, they have to complete a full means test, so they've got to complete this CRIM 15 form. They've got to show evidence of pay slips, tax returns, bank statements, mortgage statements, rent, and tenancy agreements and child costs. And you can see there's loads of proofs you have to obtain from the client in order to obtain legal aid, and it can be a right headache. A question here: can a defendant appeal a refusal based on the means test? There's no direct appeal, but a person can apply for a hardship review by completing a CRIM 16, must demonstrate genuine inability to fund the defence. Exceptional hardship applications, you've got that as well. Applications when failing the means test but unable to afford representation. Example would be a sole breadwinner with high expenses exceeding income thresholds. It's a real headache when you have to trying to obtain information and proofs where the means has been refused and you have to make a hardship application. So what is the scope of the representation order? Well, it covers the Magistrates Court, all proceedings. Crown Court extends coverage if sent to trial, and it also includes appeals against conviction and sentence, but it's pretty much limited to the barrister. Will a defendant contribute towards legal aid at the Crown Court? Yes, and you've got a figure there, 12,475. Contributions may be required. You may be able to get refund possible if the person's acquitted, and I've obtained that on a few occasions too. Do young people qualify for legal aid? Well, at the police station, yes, they do. There's no means test there. Magistrates Court, as long as they satisfy the interest of justice test, but it's not means tested for them. They automatically would pass that. Crown Court automatically met for trial, but it is and it's not means tested either. Summary of takeaways then is legal aid ensures fair representation. It's a two-part test: interest of justice and means test. appeals and exceptional hardship applications available for rejections on the means tested side. And remember those test your knowledge questions. Well, please feel free to pause this slide and see the answers. Questions 1 to 8. Again, test your knowledge question 2. Look at the answer. Feel free to pause the slide and the video and check your answer. Question 3. Again, feel free to pause the slide and the video and check the answer and the feedback. Question 4, that's the sample, very similar to one of the other questions. Again, feel free to pause the slide and the video and check your answer. Finally, as always, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning and legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book. Attend and participate in class. Prepare your Q&A flashcards. Practice as many of those SBAQ questions as possible. Don't forget to subscribe to Community Legal Education on YT YouTube and put your notification on so you don't miss out on more SQE prep videos. Hope you found it useful. Hope you found those SBAQ questions useful. See you in the next class, and thank you for watching.